In this video, I will explain the political and constitutional controversy over the effect of Brexit on the powers of devolved government. Clearly, all parts of the United Kingdom have an interest in Brexit and its consequences, but two factors give the territorial dimension of Brexit an extra political twist. The first is that different parts of the United Kingdom voted in different ways in the European Union referendum. There was a narrow majority for Leave across the UK as a whole, but clear majorities for Remain in both Scotland and Northern Ireland. The second factor is that we have extensive devolution of power in the UK, with elected assemblies and executive governments both responsible for a wide range of policy areas in three of the historic nations of the UK, that is Scotland, Wales and Northern Ireland. Apart from the general economic and social consequences for their nations of Brexit, the devolved governments are naturally very interested in whether Brexit will have any implication for the powers that they exercise. So, the political background to the dispute over the devolved government's powers is that the people in the different parts of the UK hold divergent views on the general merits of Brexit, and so do the political parties and governments in power in different parts of the United Kingdom. The legal background is that the devolved assemblies and governments have substantial and wide-ranging legal powers to legislate. The scope of that power is set out in the devolution legislation. And whilst there are differences of detail, in all three devolved systems of government, a similar technique has been used to devolve power. This is known as the retaining model of devolution. Now, all that means is that the legislation specifies those powers of government that are to be exercised by the United Kingdom Parliament, and all the rest are devolved. Thus, if any power of government is not mentioned in the legislation, it is devolved. The powers to be exercised at UK level include defence, foreign affairs, taxation and the currency. In the Scotland Act 1998, these are described as reserved matters, and for convenience I will use that term in discussing all three devolution schemes throughout this video. In some of the devolved policy areas, the devolved assemblies can enact any legislation they please, subject to human rights requirements, and so long as it applies only in the relevant nation. Whereas in other areas, their freedom is more limited, because any legislation they make must comply with European Union law. European Union law imposes substantial constraints in certain areas, notably agriculture, fisheries and the environment. Before the European Union referendum, the direction of travel had been towards increased powers for Scotland, Northern Ireland and Wales, and no one imagined that any of the devolved powers might be taken back to UK level. Brexit has confounded that assumption. The UK government, in the white paper that it published in March 2017, showed that it was considering taking back powers to UK level. The white paper stated that powers might have to be taken back to the centre wherever common UK frameworks would be required to maintain the effective functioning of the UK single market. This approach was immediately denounced by the Scottish and Welsh governments as a power grab. Precise proposals for taking power back to the centre were included in the European Union Withdrawal Bill, which is currently being considered by the UK Parliament. The main purpose of that bill is to set out the consequences in domestic law of leaving the EU. The basic principle is that laws currently applying in the UK, which are derived from our European Union membership, will have continuity of effect. Basically, after Brexit, the law in those areas will be the same as it was before Brexit, although it can always be changed in future by new legislation enacted by the UK Parliament. All of this law that is to be carried forward in this way will be known as retained European Union law. The most significant provision of the bill for devolution is Clause 11, which says that after Brexit, the devolved assemblies will not have power to legislate to change any of this retained European Union law. Only the UK Parliament will be able to change it. But as I said already, many of the relevant policy areas are devolved in terms of the Scotland Act and the other devolution statutes. So, although the United Kingdom as a nation would acquire greater legal freedom of action in many policy areas as a result of Brexit, none of this greater freedom would accrue to the devolved assemblies. It would all go to the UK Parliament. It is important to note that this general rule does allow for exceptions. The bill gives the power to UK ministers to make subordinate legislation to release powers in specific policy areas back to the devolved assemblies. However, that would be a decision for UK ministers alone to take. There is no legal obligation on them to release any powers in this way, and no legal mechanism for the devolved institutions to force the release of powers back to them. To make it clearer how this works, here is an example. Agriculture is a devolved matter. So, for example, the Scottish Parliament has the power to make laws regulating agriculture. But many aspects of agriculture are also regulated by EU law, including the important matter of subsidies for farmers. These form a large proportion of farmers' income. Any legislation on agricultural subsidies that the Scottish Parliament makes has to be compatible with EU law. Similarly, much legislation on the environment, whether it affects farming or other activities, has to be compatible with EU law. If the bill is enacted as it now stands, then after Brexit, the Scottish Parliament will simply have no power to make any legislation on agricultural subsidies or on many aspects of the environment. So why is the UK government proposing this? Well, they point out that there are now common frameworks in areas such as fisheries and agriculture, which are, in effect, imposed by EU law, and that if after Brexit the different parts of the UK were to legislate differently in these areas, there would no longer be a single UK market, and this would be bad for those industries and the economy. So the UK government wants to make sure that this does not happen. It also says that taking power back to the centre across the whole range of policies affected by EU law is only a temporary measure while it decides where common frameworks are needed. It anticipates that powers in most areas currently covered by EU law would be released back to the devolved institutions, with only a minority being retained permanently at UK level. The opposition to these proposals has been led by the Scottish and Welsh governments. The Northern Ireland parties have been less involved in the debate because devolution has been suspended since January 2017. The Scottish and Welsh governments have objected to the bill's proposals as a power grab, because in terms of the devolution legislation, the policy areas in question are all devolved. So this does, as a matter of law, amount to a reversal of devolution in those areas. They say that they accept in principle the need for common frameworks in areas like agricultural subsidies, but that these common frameworks ought to be reached by agreement between the UK government and devolved governments, rather than being imposed unilaterally by the UK government. They do not think that the power to make exceptions makes much difference, as this too would be a unilateral act of the UK government. The Scottish and Welsh governments have also made some more specific criticisms of the proposals in the bill. These include, first, that what the bill proposes amounts to a major change in the balance of power between the UK and devolved levels of government. It involves a shift from a system in which both the UK and devolved levels of government are subject to the constraints of European Union law, to a system in which only the devolved levels of government continue to be so constrained. Secondly, whilst there are good arguments for developing coordination between the UK and the devolved levels of government after Brexit, this does not justify the allocation of all of the competences that will be repatriated by the EU to the UK level after Brexit. Thirdly, Clause 11 would alter the current reserved powers model of devolution and replace it with a conferred powers model across all areas that are now covered by EU law. This is not just a legal technicality. The reserved powers model has always been considered a central constitutional element of the devolution schemes. The preferred approach of the Scottish and Welsh governments is therefore that the powers in question should remain devolved. There have been negotiations between the UK and devolved governments to try to resolve this dispute, but so far without success. The UK government has put forward a compromise proposal, which involves a much shorter list of powers being taken back to UK level. And on the 12th of March 2018, the government tabled amendments to the EU withdrawal bill in the House of Lords on this issue. But the amendments were then withdrawn after debate without a vote, so there is currently no agreement in place. So what is likely to happen? Well, we cannot be certain, but perhaps the most likely outcome is that the UK government brings forward new amendments to Clause 11, that these are then opposed by the Scottish and Welsh governments as being inadequate to address their concerns, and that the government proceeds with the bill anyway. But that raises a further constitutional issue, the Sewell Convention. The Sewell Convention states that the UK Parliament will not normally legislate on a matter that is within devolved competence without the consent of the Scottish Parliament, the Northern Ireland Assembly, or the Welsh Assembly, as the case may be. The Convention has been extended to include alterations to the scope of devolved competence. As Clause 11 restricts devolved competence, it would appear that the Sewell Convention applies. And indeed, the UK government has accepted that it does, and that the consent of the devolved assemblies is required for the European Union withdrawal bill. However, both the Scottish and Welsh governments have said that they will not recommend that consent be given to the bill in its current form. If no agreement is reached between the UK and devolved governments, and the devolved legislatures do refuse to consent to the European Union withdrawal bill, the UK Parliament would then have the choice either to respect the views of the devolved assemblies and withdraw those aspects of the bill which affect matters that are within devolved competence, or alternatively, to ignore the absence of consent and enact the bill anyway. In the recent case of Miller against the Secretary of State for exiting the European Union, the Supreme Court confirmed that the Sewell Convention is politically binding only. Whilst it has received some recognition through being mentioned in the Scotland Act 2016 and the Wales Act of 2017, that does not make it a legal obligation. However, it would be a major constitutional step to override a refusal of dissolved consent. It might be argued that such a step would be justifiable, as Brexit constitutes an abnormal situation and so falls out with the scope of the Sewell Convention. But there is no clear constitutional understanding as to what circumstances are sufficiently abnormal to justify ignoring a refusal of devolved consent. The situation has never arisen before. It is at least arguable that given the seriousness of the constitutional issues at stake, lack of devolved consent should only be overridden in cases of absolute necessity. Clearly, it is not necessary that the European Union withdrawal bill be enacted in precisely its current form in order to secure an orderly Brexit. If the bill is enacted over the objections of the Scottish and Welsh governments and of the assemblies, some think that this will provoke a constitutional crisis, whatever that means. It will certainly sour what are already poor relations between the UK and devolved governments, and that is likely to make implementing Brexit even more difficult than it already is.